Every day in the USA, people find themselves in court.
I think let's go on the record. In the matters of City of Wyandotte versus Stephanie Shackelford, 26929, 26860, 26598A, 26808A and B, 26809, 26810, 26. I think that's all of them. All right.
I think it was Stephen. And good morning, Your Honor. David Bogart appearing on behalf of Ms. Shackelford. Appearing from Zoom technology and consents to appearing via Zoom from Wayne County Jail. Ms. Shackelford, please unmute yourself and tell the court your full name.
Stephanie Rose Shackelford. Good afternoon, Judge.
All right. Good afternoon. Okay. And so,
Your Honor,
today is the date scheduled in this matter for a number of matters. We have on the 26929 the pretrial for the assault and battery matter, and I believe there's also a bond violation in that regard. And then there is also the bond violation on 26809. This matter was originally adjourned to July 29th, but moved up to today's date based upon all the other cases. Then on 26598A and B, this is also scheduled for an adjourned pretrial. It was originally scheduled to July 29th. She had claimed she retained Mr. Bassett on this one and the 809 matter, but it's Mr. Bogart. It's been retained and filed an appearance. Then on 26810, again, this was adjourned and for the 29th, it moved up to today's date based upon the bond violations. And then also based upon her new charge from July 9th. And then the 26860 is a true pretrial after her in custody arraignment on July 9th. So, there's a lot going on.
Rather, I think that's an accurate recitation of the cases.
Okay. So, counsel, as to the pretrials in these matters.
As to the pretrials, Your Honor, I don't think we'll have the difficulty picking the days as we did with the last time we were discussing a case. I had met with prosecuting attorney as well as Ms. Shackelford, and so that I could get the discovery, I'd ask for one more pretrial, Your Honor, an adjournment of that. And then at the court's discretion, if we could pick a date with that.
Okay.
I understand the 29th is too soon, and I understand that there's no docket on the 5th, Your Honor. I would be amenable to the 12th if that is okay with the board.
Okay. Your P number is 74745, counsel?
That's correct.
I don't know how I remember that, but I did. Okay, just so I can write that in on all these. All right. The court assigned the discovery orders in each of these cases that has been requested. And then, counsel, let's hold off on the new pretrial date. Let's handle the bond violations in these matters. Your client, so all of these matters are bond violations. I believe that there's different bond violations for different cases.
I believe that's accurate, Your Honor.
Because on the, bless you, on the matter, from on the 810 matter, your client was ordered not to possess or consume any alcohol or drugs unless prescribed, no contact with Miss DeBono or McKnight, and not to return to the victim's address. And then as also, bless you, on the back of her bond condition that indicates that she will not violate any laws either. Or any further will not commit any crime while released. On the back, under terms and conditions. And for that bond violation, it's alleged that she was then charged with larceny and wind down on June 20th, and assault battery on July 9th, which is the 26929 matter is the assault battery, and the 26860 is the larceny matter. So those have resulted in the bond violation on 26810, and I'm going to presume also on 26598 as to that bond violation as well. So as to those bond violations, counsel, what is your client prepared to do today?
Your Honor, on all the bond violations, I would remind you that obviously my client is innocent until proven guilty at this time, but Judge, she is prepared to plead guilty on the bond violations today.
Okay. So Ms. Shackelford.
Yes, ma'am.
I'm going to have you please raise your right hand. Do you solemnly swear, or the other right hand, do you solemnly swear from testimony about to give in this matter the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. And you've heard the allegations for the bond violations for the new charges, correct?
Yes.
Okay. And then the bond violation for, just get these numbers correct here. I'm sorry. Sorry. The bond violation allegation for 26598A, 26810, and 26860. Which those bond violations are that you violated the conditions of bond by being charged with new crimes. June 20th June 20th larceny, July 9th assault and battery. Correct?
Correct.
You've heard those allegations.
I have.
I think I'm missing case numbers on here, but and then 26809, it's also the same allegation of bond violation, correct?
Correct.
Sorry, counsel, there's so many files and I have to write in each of these files. And so
Your Honor.
it's quite time consuming. And then the bond violation also on case number 26808A is also because you were charged with another charge of larceny on June 20th and assault and battery on July 9th, correct?
Correct.
All right, so as the bond violation on all of those cases, how do you plead?
Guilty.
In the bond violation as to the 26929 case where it's alleged that you violated, oh no, you may not have one on that. Let me see here. There's a bond violation. I don't seem to have that one. Oh, it's alleged you violated your tether on that one. And that it's alleged that you violated the terms of condition of bond because you had contact with Mr. Wolfile. That's the allegation on that bond violation.
Okay.
As to that bond violation, ma'am, how do you plead?
Guilty.
Turn off your phone. Turn it off. And you understand all of your rights
Yes, ma'am.
for bond violation purposes, correct?
Yes, ma'am.
You also understand that the possible penalty as a result of your bond violation. Correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way through the end of this
No, ma'am.
plea? Counsel, can you please voir dire your client? Let's go, I'm sorry, just for ease of the record. Well, let's go with all of the cases except for the 929 case, because those are all the same allegations for the larceny and the A&B charges, correct?
That would be correct.
Okay.
Ms. Shackelford, you heard the court explain all the cases ending in 810, 860, 809, where there is supposed to be no other charges. You heard that, correct?
Yes, sir, I did.
And then other charges were picked up, such as, doesn't mean you're guilty. It's just other charges were picked up by you. You were charged again on June 20th for larceny. Is that correct?
Yes, that's correct, sir.
And again, it doesn't mean you're guilty. You were charged again on July 9th for assault and battery. Is that correct?
Yes, that's correct, sir.
Now, with respect to all of those cases that Judge Suzanne read, that was a violation of those bond conditions, correct?
Correct. That was.
All right, the court is satisfied in those matters that the plea is knowing, voluntary, and factually accurate. And then counsel adds to bond violation for 26929.
As to the, you want me to voir dire that one?
Yes.
Okay. As to the 929 case, that is the assault and battery for which you have been charged with. You were on a tether and you had a condition to that. Is that correct?
Correct.
And then there was a no contact order with the alleged victim, which is Keith Woolfield, correct?
I think the court is confused on these two charges. The assault and battery charge that happened before me and Keith had a no contact order.
No, ma'am. Excuse me. The bond violation for the assault and battery case, the 929 matter, the court ordered you not to have contact with Mr. Wolfile. And and also Wayne County Jail GPS tether house arrest. And it's alleged per the report from Wayne County Jail Tether Unit that you did in fact have contact with Mr. Wolfile as the two of you were seen arguing with each other upon the Trenton police arriving to your home. So that
Yeah.
was the violation for this matter because of the contact between you and Mr. Wolfile.
Okay,
And
yes,
that's what
that
we're
is
talking
correct.
about.
Okay, I just wanted to
Okay.
be clear.
Yes, you're
Okay.
good.
And and on that bond violation, you concur with what the court just stated. Is that correct?
I do concur.
Your Honor.
All right. The court does find the plea is knowing, voluntary, and factually accurate as to that bond violation as well. All right, counsel, let's address the bond violation and the sentencing on that matter.
Your Honor.
Address the new date.
Thank you. I've spoken to Ms. Shackelford at length, and I've spoken to her mother as well. She does understand rights. Your Honor, she does have counsel now. I believe I'll be able to speak with her more clearly on how she should behave, not only in public, but around Mr. Wolfield as well. Obviously, not to have contact with him. She has spent 5 days in jail right now, Your Honor. We would ask for a bond that she could at least pay or possibly allow her to be out so that she can address these multiple charges and assist me in her defense. Obviously, the court is aware of who she is, Judge. She's very high spirited and probably needs to have her emotions kept a little more in check. And Your Honor, when I looked at all of these from the limited time that I had to look at them, it did not appear that there was anything that involved drugs or alcohol with her that I was aware of. I may have missed something, but I didn't think I saw anything like that. And outside of this, these misdemeanors, there are several of them, Your Honor. But, and I'm not trying to minimize them at all with the fact of the larceny or the assault and battery. But most of these other misdemeanors are certainly on the lower end of the spectrum. And I'm not advocating that that's something that's simple to write or anything like that. I'm just saying that at least this hasn't risen to another level. And I believe that now that she has counsel, I would ask the court to give her time served on this, allow her to assist and aid in her defense, allow that if the court sees this with the other attorney that would be involved with Mr. Wolfield, because they are fiancés and they intend to be married, no assault of contact with each other. And that's what we would ask for at this time, Your Honor.
Okay. So, Ms. Shackelford, I don't know how much more clear this court can be. Counsel, on another housekeeping matter, I believe that we need a discovery order on the, oh, never mind, it's right here. I got lost here. I don't know how much more clear I can be, ma'am. You've been on bond in this court a number of times, not counting the 6 cases that I have before me today. You've had prior matters here that you've been on bond for. And it doesn't seem as though you get it.
I'm sorry, Your Honor.
One of the, ma'am, and I can appreciate that. And I hear that a lot from you. But what I don't see is I don't see that you're sorry. I don't see that you're trying to make changes to your behavior and your choices. You are here for multiple bond violations. 5 of your 6 cases are because you picked up new charges. Okay? 2 new cases. And then the new case, this court ordered no contact. And we were going to bring this case back up on July 9th when I arraigned you, because as soon as I was done arraigning you, I received information that you were trying to talk to Mr. Wolfile in the back lockup at the Wyandotte Police Department. Despite this court telling you right then, there's no contact. It seems, ma'am, as though you have an issue with self-control and discipline. as evidenced by the plethora of charges that are before this court.
I'm sorry, Your Honor. I'm not going to make excuses, and I apologize for my behavior, and I'm ashamed.
Ma'am, at what point do you stop the cycle that you're on?
Yes. I am trying. It may not seem like it, but I am.
Okay, well, here's what this court's going to do. Given Ms. Shackelford's inability to follow the bond conditions of this court, while the court can respect that she has retained counsel in these matters, it is evident that Ms. Shackelford has an extremely challenging time following this court's orders. And one of the purposes of bond is to ensure the safety of the public and the safety of the named victim in the matter. And while you and Mr. Wolfile's relationship, or what it may have its own issues or challenges, this court still ordered that you are not to have contact, and you could not follow that order of the court. Further, the court needs to take into account the safety of the community. And given that there's a trespassing and a disorderly conduct charge on one matter, you have a larceny charge on another matter, another disturbing the peace, which I believe those might all be similar in nature in your neighborhood, another disorderly conduct and disturbing the peace, and then the assault battery. The court is going to order the following. The court's going to order on case number 26810. The court's going to order 10 days jail, credit for 5 days, consecutive with two 6,929, 26860, 26598, a 26808, a 26809, as to 26808A, the court's going to order 5 days jail, consecutive with the balance of your cases. 26929, 26860, 26598, a 26809, and 26810. Two 26598A, the court's going to order 5 days jail, consecutive with 26929, 26860, 26808, A 26809, and 26810. As to 26809, 5 days jail, consecutive with 26929, 26860, 26808A, 26598A, 26810. As to 26860, 5 days jail, consecutive with 26929, 26598A, 26808A, 26809, 26810. As to 26929, the court's going to order 10 days jail, consecutive with 26860, 26598A, 26808, A 26809, 26810. All right, now, as to the pretrial counsel, I've signed all the discovery orders for each of the cases. I even triple checked. There's 6 of these here. Quadruple check now. So there's 6 of those. So the pretrial, we'll adjourn the pretrial. We can adjourn this to August 26th, counsel. Your client will.
You said consecutive, correct, Your Honor?
Correct.
And there's no way for the court to reconsider any of those?
No. My other option was going to be a revoked bond, but I'm not going to do that at this point. Because your client doesn't know how to follow court orders when she's not in custody. I will counsel your client's interest that I can tether her to treatment. Although I don't know that there's any mental health treatment facilities available through the Wayne County Jail to be tethered to.
I would ask the court to do that if there becomes one available, because if the person is having these kinds of emotional issues, Your Honor, I think that might be appropriate. And the 26th would work, Your Honor.
All right.
At what time?
My boss is going to hand that to us in just a moment.
1:15.
Thank you.
All right, so
Yes.
I'm tethered to treatment through Wayne County Jail. Yes, ma'am.
Can I ask a question?
Sure.
How many days total was that I was sentenced to?
25, 35 total. It was 40. I gave you credit for 5 of your days that you've already been in.
Thank you.
You're welcome.
Thank you.
And I will indicate tethered to treatment through Wayne County Jail. Counsel, your client may even be interested in the treatment court that we have here, which is the mental health treatment court. That may be something that your client's interested in, because I would say that given the 6 files we have here and the number of times that we've seen your client prior to today, that there seems to be some significant issues that your client has not dealt with.
I'll explore that issue with her, Judge.
All right. Good luck to you, ma'am. We'll see you back on August 26th.
I'll be in touch, Michelle.
Yep, thank you.
Okay, have a good day.
You and your staff have a good day as well.
Thank you, you as well.
Sorry it took so long.
No, that's okay, Counsel. Let's see.
Yeah.